Wish to. Right, ready? You're recording. Okay. Good evening. Thank you all for coming. I am going to go ahead and call this meeting to order. We're going to start with a roll call. No takers, I'll go first. I'm Candace Conway. My last name has just recently changed. I am District 2.
Sean Gardner, Community Development Director.
Brittany.
Everett Neal, Code Compliance. John Barrett, Delta County Attorney.
Travis Warren, Assistant County Attorney.
Kim Kelly, District 3.
Okay, before we move on, I just want to make everyone aware that if you do not wish to speak today, but would like to submit something in writing to the commissioners, there are comment sheets available by the entry door somewhere, correct, Brittany? Comment sheets?
No, we don't have comment. Just sign in, just speak it.
Okay, so we're just signing in. Apologize. Individuals wishing to speak, please address us as the Board of County Commissioners, the Board of Adjusters. Please come forward to the microphone, speak clearly, state your name, address, and please keep your comments specific to what's on the agenda tonight. Be brief, to the point, and we are going to cap time out. That looks like there's quite a few people wanting to speak tonight, so we are going to cap time out at 3 minutes, and we will field public comment on this agenda in the order of which it was received and signed up on the form. So right now we're going to go ahead and open it up for public comments that are not particular to this agenda item. Is there anyone in the public that wishes to speak? Yes, sir. Could you come up to the mic and state your name and address, please?
Mike Jackson, 40286 Cedar Lane, Paonia, Colorado. And I'm going to say not specific to this because my comments have more to do with how we got here, why we're here. And that in Delta County, this idea that the best thing about Delta County is you can do whatever you want with your property. And the worst thing about Delta County is so can your neighbor. Who's heard that? And the property rights crowd, right, that can be vocal, might say there should be no regulations. Need to think about the idea that we can swing our fist, but only up until it hits someone else, right? And so part of these regulations are designed to avoid that. And I worked in the real estate business. I've seen some of the consequences, some of the unintended consequences of lack of enforcement, lack of regulation. The chicken wars were about that. And that generally no enforcement or lack of enforcement has reinforced the idea in the public that there weren't regulations. And because there's no building permit, people could do more or less what they wanted. I have a client who took 2 years to sell her house because they built a garage in the setback and in the right of way. And that was their own fault. But it was a problem. Buyer would say, someone gonna potentially make me tear down my garage someday? I visited with folks here and the answer was maybe. So another lady asked me to help because she needed to pump her septic tank as a condition of sale. I can help. Look at the septic permit, which was luckily on file. Oh yeah, did you put this addition on your house? Oh yeah, don't you like it? Well, it was under the hot tub, sitting on a slab inside a sunroom. Now, is the county here to protect us from ourselves? No. Which makes me kind of think that property rights are like gun rights in Delta County. And you are free to shoot yourself in the foot. Which may be partly what this is about tonight. And that when the site plan requirement was removed from the LUC with the 2024 revision, it took away the gatekeeper that might help prevent those sorts of problems. Thank you.
Thank you. Any other comments before we move along?
No, I'm good. Because we're gonna do, yeah.
Okay.
We
Okay.
might just address that public comment for this application will be accepted. Public comment for this particular application will be done if y'all have agendas after the presentation, but before we make a decision. So it'll be a little bit later that you can all, anybody that signed in can make a comment in order to save time, because we might be here for a while. If you agree with whoever just spoke, if you just list your name, address, and I agree with the person in front of me, kind of thing. Yeah. If you got something else to say, please do. Okay.
Very good, thank you. Okay, agenda additions, deletions, and corrections. Are there any?
Anyone here?
How about with the meeting minutes, the last meeting minutes?
Not to jump ahead, I would make a motion that we accept the meeting minutes from the last meeting. I've made a motion to accept the minutes from the last meeting.
Bill can't hear you.
Okay, can you hear me now? Yes, no, maybe? Can you? All right, maybe we've got the right.
Maybe.
Yes, you could be right. One more time. I'm making a motion that we accept the minutes from the previous meeting as presented.
I would second that.
Okay, the motion has been made and seconded. All in favor? Aye.
Aye.
Any opposed? Seeing none, we will approve the minutes from the last meeting. Okay, moving on to scheduled items. We are here to discuss APL 25-001 for Austin. Considering an appeal of determination from the Planning and Community Development Director's decision to classify 41339 Highway 33 as unlawful non-conforming use. This parcel is located north of Highway 133 in Paonia. Parcel number 318-729-300042.
Before we go any further, I'd like to
Can't
Just-
hear you.
make a notation that I visited the site this past Monday and actually met with one of the owners, and the other owner was on the phone. I told him we couldn't discuss anything between us, and I was blocking their driveway at the time, so I didn't want them to think I was just some wingnut blocking off their egress up there. So I just wanted to bring that up in case anybody saw me there. That was what happened. That was it. And it should have no bearing on my hearing this case.
I would also say that I do know Tim Austin, and I did talk to him briefly about this and informed him that I was with the BOA and that I couldn't talk to him about it, and he was perfectly okay with that. And I believe that that would have no impact on my decision tonight.
Okay, perfect. Moving along, are we ready for presentation?
Yep.
Great.
This case is an appeal to the Board of Adjustments to consider whether to reverse or affirm or to modify a determination that was made by myself as Community Development Director with respect to Fort Austin, a lodging and event venue located at 41-339 Highway 133. In my presentation, I will share the criteria for the board's decision according to the Land Use Code, the definitions of a legal nonconforming and an unlawful nonconforming use, the origin of this case and how and why the determination was made, and the evidence and authority used to make the determination. The criteria for your determination, according to the Land Use Code, in response to an appeal, the Board of Adjustments may reverse or affirm wholly or partly, or may modify the order, requirement, decision, or determination as ought to be made, where the board finds that the director acted, number one, without clear and convincing evidence to support the order, requirement, decision, or determination, or secondly, acted beyond the director's authority. So the board has three possible motions: reverse, affirm, or modify the determination. Although I don't know really how you can modify, it's probably more of a reverse or affirm. And the board's decision is to be based on one of two findings: that the director acted without clear and convincing evidence, or the director acted beyond his authority. So there are two terms that are fundamental to understanding the determination that has been made and the appeal to that determination. The definitions pertain to two ways of classifying existing land uses that do not strictly conform to the Land Use Code's requirements. These are found in Chapter 11 of the Land Use Code. Legal nonconforming. Legal nonconforming means any use of land or structure that existed in conformity with applicable federal, state, and county laws and regulations at the time it was established, but which does not conform or comply with current laws and regulations, and may continue to be maintained and used as a lawful or legal non-conforming use, as set forth in the chapter that this definition is contained in. So this is the status Mr. Austin believes Fort Austin should be found to have. Sometimes this is referred to as grandfathered. Non-conforming, unlawful is any use of land or structure which was not in compliance with applicable regulations when established, shall be considered unlawful and may be subject to enforcement action except as provided in this chapter. This is the status I determined applies to Fort Austin after examining the evidence. My analysis concludes that at the time the property was purchased by Austin Family Trust, May 2nd, 2014, what can be known and verified about the property at the time appears to have been in compliance with the regulations at the time. At the time, there was a single-family residence, a grandfathered access from Highway 133 for one home, an exempt domestic well permit for 3 single-family dwellings, the watering of not more than 1 acre of home gardens and lawns, and the watering of domestic animals. And I assumed there was a septic system for the home on the property. All legal and conforming, all this appears to be legal and conforming to the laws and regulations that were in effect at the time that those things were established. However, at some point after purchasing the property, the land use was increased beyond the residential use and commercial uses were developed. The single-family residence was turned into a commercial lodging facility. 5 rentable structures, cabins and a glamping tent were added, and a pavilion and restrooms were constructed for hosting events for revenue. My assessment of the evidence leads me to conclude that these intensifications of land use led Fort Austin to no longer be in conformity with applicable federal, state, and county laws and regulations at the time they were established. I'll now give an account of the history of our communications from the reception of the initial complaint up to the time of the appeal application was submitted, and then go over the evidence that led to my determination. All right. On January 23rd, 2025, pretty much a year ago, Delta County Code Compliance received a complaint form from an individual who was in the process of applying for a permit to develop an event venue on their property a mile off of Highway 92. CDOT required that applicant to pay for the construction of a deceleration turn lane for the development. The applicant submitted the complaint in person with verbal explanation questioning how they could be required to pay for the design and construction of such a highway improvement when there are existing event venues directly off the highway that do not have turn lanes nor appear to have any requirement to construct them. On February 6th of 2025, that same complainant brought a picture of the entrance to Fort Austin, also reporting that this venue advertises itself as an event venue and is directly off the highway without a turn lane. Because this complaint questioned the fairness of our land use permitting and CDOT's fairness of access permitting, and made us aware of potential regulatory violations and safety hazards, we couldn't just ignore the report. We have a legal, ethical, and regulatory duty to look into such situations when they're brought to our attention. We have a legal duty to enforce state permits for highway access, well water, and regulations for septic systems. We have an ethical duty to exercise consistency and equity in the application of the regulations and the issuing of permits. We have a regulatory duty to protect public and environmental health and safety according to the Land Use Code in Chapter 1. And we have an explicit policy to encourage bringing a developed parcel into full compliance with regulations according to Chapter 11 of the Land Use Code. So we looked into Fort Austin. Had we found that the commercial activities of Fort Austin were in compliance with the federal, state, and county laws and regulations at the time they were established, we would have simply been able to report that Fort Austin was a legal conforming or legal non-conforming property. And we would have explained that to the event venue applicants, the reasons why Fort Austin was not subject to the same requirements that they were. However, that is not what we found. Rather, we found that they had no access permit for their access off of Highway 133. They also had a domestic well permit servicing their commercial activities. They had no record of a septic permit, and they did not have a specific development agreement, which would have been required for such an operation prior to the 2021 Land Use Code, nor did they have a limited or conditional use permit that would have been required after the adoption of the 2021 Land Use Code. So, on February 26th, Code Compliance Officer Neal issued Mr. Austin an advisory letter requesting that he contact him to discuss possible violations and assist in the process of coming into regulatory compliance if needed. That is in attachment 1 of the board's packet, along with the complaint photo, the photo of the front of Fort Austin that was submitted as part of the complaint. On March 20th, 2025, Officer Neal, myself, and Environmental Health Director met with Mr. Austin and one of his investment partners to discuss the advisory notice, the commercial activities taking place at Fort Austin, and regulatory compliance requirements. Notes from that meeting are in attachment 2 of the board's packet. On June 2nd, 2025, Code Compliance issued Mr. Austin a notice of unlawful nonconforming. This was a statement of Fort Austin activities that require permits. The notice did not have any order or requirement to become permitted. It was just a statement of here's where you're out of compliance and here's what it would take to get into compliance. The notice, it was a gentle and lenient approach to continue to invite them to work on the identified compliance issues. From September 12th, 2025 to October 8th, 2025, several emails were exchanged between Mr. Austin and myself, beginning with an initial email from Mr. Austin to Commissioner Kuntz, requesting a hearing with the county commissioners to hear his claims, alleging the illegitimacy of the complaint against his property and contesting the notice of unlawful nonconforming. He requested to meet with the Board of County Commissioners so that they could determine that Fort Austin should be recognized as a grandfathered in property, which would be equivalent to the legal nonconforming. In response, Commissioner Kuntz directed Mr. Austin to submit an application to planning, which began his correspondence with me. On September 26, Mr. Austin asked me for a form to request that his land be grandfathered, determined, in other words, to be legal nonconforming. He cited a section of the land use code that states that I have authority to make that determination. On September 29th, I responded by asking him to provide me with the date, the month, and the year that the 5 cabins were constructed, and he started events. On October 3rd, he replied that he started the first cabin in 2017 and started the last one in 2020. And his first event was in 2014. However, on October 2nd, the day before that, I had already reviewed evidence available through public records and satellite photos and had told him that I could not agree to find Fort Austin as legal nonconforming based on the evidence. On October 8th, Mr. Austin emailed me 5 questions, 2 of which were, what land use on my property was not in compliance with applicable regulations when established? And the second, what evidence have you uncovered on which you to base your finding of notice of unlawful nonconforming property? This correspondence is all in attachment 4 in the board's packet. On October 9th, I issued a letter in response to the questions posed by Mr. Austin in his October 8 email, answering his questions about the regulations and evidence we had to substantiate the notice of unlawful nonconforming. My response established my determination as director, which is the basis of this appeal. The letter and those attachments that were sent at that time are in attachment 5 in the board's packet. And then lastly, on December 9th, Mr. Taggart Mosholder submitted an appeal application on behalf of Mr. Austin and Austin Family Trust, alleging the director of planning acted without clear and convincing evidence and beyond his authority. That's in attachment 8. That's the origin and evolution of this case. Now the evidence used to make the determination. The county has an intergovernmental agreement with CDOT and the town of Paonia covering the Highway 133 access control plan for this section of the highway where Fort Austin is located. It went into effect on June 6, 2012, before Austin Family Trust purchased the property in 2014. Access point number 72 of the table included in Exhibit A of this agreement shows the access for Fort Austin is being permitted for 1 home. At the time that Austin Family Trust bought the property, there was just 1 residence, so the highway access was considered grandfathered at that point in time. However, at some point after the purchase date, the land use changed from a single-family residence to a commercial lodging and event hosting business. At that time, the use of the access intensified. Accommodations for 16 overnight guests, that's 1 glamping tent, 4 cabins, 3 deluxe apartments, and up to 80 guests for events were developed on the property. Fort Austin does not have an access permit from CDOT for this commercial use. CDOT requires Fort Austin to obtain an access permit, as is evidenced by communication from CDOT's Region 3 Access Program Manager, Brian Killian. On February 24th, 2025, Mr. Killian contacted Fort Austin through the wedding venue reservation page on its public website, in which he says, CDOT doesn't have any record of any access permit for your property. Due to that and the fact you're running a business, you will be required to obtain a CDOT access permit. In subsequent emails, Mr. Killian instructed Mr. Austin to contract a qualified traffic engineer to provide a traffic study, the basis upon which CDOT makes access permit determinations. On November 13th, 2025, approximately 9 months after initial contact, Brian Killian followed up with an email inquiring about Fort Austin's status with the required traffic study and access permit application. This email correspondence is included as attachment 6 in the board's packet. Mr. Austin has not obtained an access permit as required by CDOT, nor submitted a traffic study from a qualified engineer. The highway access was grandfathered for 1 home, 8 rental units and event venue were added. CDOT required Fort Austin to obtain an access permit in February last year. Fort Austin has not obtained an access permit. Therefore, Fort Austin's highway access permit has been considered non-conforming, unlawful. As director, I cannot make a determination that Fort Austin's highway access is lawful conforming. I have to conclude that it is non-conforming, unlawful until it is permitted. Next piece of evidence, the well permit for Fort Austin is for 3 single-family dwellings, 10 head of livestock, and 1 acre of lawn and garden. It was originally constructed in 1961 and then permitted to be relocated in 2018. The relocated well was constructed on December 11th, 2018 and permitted as residential or exempt domestic well. Evidence of this conclusion is provided in the board packet as attachment 5, which contains the residential water well permit application and well permit number 311570A. This well permit is not for commercial use, as is further confirmed and evidenced in a letter from Greg Powers, the Colorado Division of Water Resources, Division 4 Well Commissioner, and that's in attachment 7 in the board packet. The letter dated February 24th, 2025 states the following. Well permit number 311570A was applied for and issued as an exempt domestic well, with the approved use being limited to ordinary household purposes inside not more than 3 single-family dwellings, the irrigation of not more than 1 acre of lawn and gardens, and the watering of domestic animals. Water from this well is not permitted to be used for any other purposes. Therefore, water from the well cannot legally be used to provide water for drinking, cooking, or sanitary purposes in a commercial venture. Mr. Powers continues the letter with instructions on how Fort Austin can apply for an exempt commercial well permit, limiting use to 1/3 of an acre foot annually, or for a non-exempt commercial well with no set limit, but requires a water court to create augmentation plan that would provide a substitute source of water to offset the impacts of the streams to the stream system from the use of the well. Therefore, Fort Austin's use of the residential well permit has been considered non-conforming, unlawful. I cannot make a determination contrary to the Division of Water Resources and say that Fort Austin's well permit is lawful conforming. I have to conclude it is non-conforming, unlawful until it is permitted correctly for commercial use. Next, septic system was installed for the public restroom that services the cabin guests and the events the event guests. Upon information and belief, the system was installed after the purchase of the property by Austin Family Trust, therefore sometime after May 5th, 2014. Delta County has had regulations requiring septic permits since 1974. On May 20th, 2014, Delta County Health Department adopted Delta County On-Site Wastewater Treatment System Regulations, formerly named Delta County Individual Sewage Disposal System Regulations. No septic permit was ever obtained for the new system installed for the commercial public restroom. So the system would have been considered unlawful nonconforming at the time of the advisory notice in February of last year. However, after our meeting with Mr. Austin, he followed the directions of the environmental health director, and on March 27th of last year, Mr. Austin did have a septic inspection conducted per the instructions of the Delta County Environmental Health Director to obtain an on-site wastewater treatment system certificate. It's a process used to document the existence and acceptable performance of an unpermitted system. However, the required application form for the certificate was never submitted, so the system is still not certified nor permitted. Once this very simple application form is completed and EH certifies the system, we would consider this legal non-conforming. Dated satellite photos of the property from Connect Explorer and Esri provide snapshots in time of approximately when the increased land uses or commercial uses were constructed. Satellite photos dated June 1st, 2019 show no cabins or pavilion or public restrooms. Photos from April 25th, 2020 show the addition of the far southwest cabin. Esri photos from April 8th, 2021 show the same southwest cabin, one additional rental structure, and one of the two grain bins. So if the lodging and event hosting began before 2021, those commercial activities would fall under the specific development regulations that were in effect at the time. Specific development regulations have been in effect since, I think, 2000. But yeah, some of the, well, there was an addition or a revised edition that's been in effect since 2014, with the other revisions made in 2015, 2017, and 2019, and in effect until the land use code was adopted in January 2021. Within the specific development regulations, there is no exemption for a public lodging and event venue facility like that of Fort Austin, even if there is nominal agricultural activity being conducted on the property. Specific development regulations, Article 2, Section 4.11, has stayed the same throughout all revisions and lists the activities requiring a development agreement. Item 11 pertains to commercial and/or industrial uses, excluding home occupations, businesses, and cottage industries. So a new commercial and/or industrial use located in a structure and/or land area where a commercial and/or industrial use has been operating shall require review if the impacts from the new use are substantially different than the impacts from the previous use. But I think what's relevant about this, can you go back a slide? Is it the section heading is titled Activities Requiring Development Agreement. Number 11 says commercial and/or industrial uses. Article 6, Section 2N lists the standards for new specific developments, and item N pertains to the provision of adequate water supply, sewage disposal, fire protection, access, roads, and utilities. As Fort Austin's commercial development activities were never submitted for review, these standards were never received or were never reviewed for compliance. As a result, their CDOT access permit was not updated for the increased use, their well water permit was not updated for commercial use, and their septic system was never permitted by the county health department. Under the land use code, in effect since 2021, Fort Austin would be classified as a guest ranch or lodging and or event venue. And according to Chapter 2, Table 2B, all zoning districts require at least a limited use permit for any of these uses. Given the event hosting, it would likely have required a limited use with notice. So all I'm pointing out here is it's unclear exactly when all the development happened and then went into operation, but whether it was before 2021 or after, if it was before, it would fall under specific development regulations as commercial or industrial use. If it was after, it would fall under the land use code and would require a limited use permit. And similar to the specific development regulations, limited use permits, these types of commercial land uses are subject to standards in the chapters 2, 3, 4, and 5 of land use code, which include the review and approval standards for access, water, and septic. This hearing is to determine whether I, as the planning director, operated on clear and compelling evidence to determine Fort Austin's current status as unlawful non-compliant, and whether I acted within my authority to do so. I submit this evidence to the board to decide whether or not I operated on clear and convincing evidence to support my determination that the commercial uses of Fort Austin were not in conformity with the applicable federal, state, and county laws and regulations at the time they were established. With respect to the question of whether or not I acted beyond my authority in making this determination, I would submit that the Director of Planning and Community Development, as the Director of Planning and Community Development, I have the authority to interpret the regulations I have referenced and to make determinations about the status of developments in relation to them. According to the executive summary in the Land Use Code, Chapter 1 defines the authority of decision makers, which includes the Director of Planning. In the summary of this Chapter 1, it references Chapter 11 for nonconformance, and it says, this chapter includes authority for the Director of Planning to interpret this code subject to oversight to the Board of Adjustment and ultimately to the Board of County Commissioners. And in Chapter 11, Section 1A2D, it states that the Director may consider any evidence that a non-conforming situation is a legal non-conformity and not a violation of this code, which is exactly what Mr. Austin requested I provide him, which I could not do because when I examined the evidence, I concluded that it's unlawful, non-conforming. This means I may consider any evidence in making my determination as to whether a use qualifies as legal non-conforming. That concludes my report.
Thank you. Okay, at this time, I'm going to go forward with board comments requests. Any other comments?
I have a couple of questions. Yeah.
My papers.
Sean, do we feel that we worked with this gentleman? Because, quite frankly, the planning department has been in turmoil for the last 4 or 5 years. And I know other people have gotten inconsistent information from one person to another. It just depends on who they asked. Are we taking that into account and giving him the option to comply with this and work with him and maybe come up with an access off Garvin Mesa instead of Highway 133 if possible, and deal with the remainder of your findings in work with him?
Oh, absolutely. That's exactly
Yeah.
what the advisory notice was invitation to discuss what's going on, what may not be in compliance. And then the more we learned and found out, we made the notice of non-conforming unlawful status. Just breaking down what were the items that were not, in compliance, and offering to help, take him through that process to bring it into compliance.
And did we offer to help him and explain to him and his group that SDRs were in effect before the land use code and that it would have fallen under that, and that was why? And he apparently, according to the paperwork, believes it should be grandfathered in. Should we correct his belief on that and try to make him come up with stuff that was non-conforming before the land use came into effect?
Well,
Yeah, he's really quiet.
Oh, I'm sorry. My voice is always, yeah. Okay.
I don't remember exactly if we spoke about like how, if it was before 2021, specific development would have been in effect, but we did address like the access, his highway access and well permit. Those are really the big issues.
And that's state and, well, it's all state.
Right. I don't know how to better answer your question, but to say, we may have mentioned the specific development regulations were in effect before the land use code, but really the discussion was on like, how can we help, get you into compliance with your access permit and your well permit?
Well, I'm saying the whole project, the items that you've listed here, if he was not aware, I mean, the normal person, if most realtors would not bother to find out, if he was going to make a event venue, if he was going to be able to, if he was advised by his realtor or not advised at all. Back then, there were very few rules in effect. And did he know, and how could he find out that there's an IGA, that the CDOT started clamping down on access in 2012 for commercial purposes? I know we've had that issue on Highway 92 and 133. Just, making sure he understands. I got the comments on, so you guys had on the grandfathered in, but explaining to him the SDRs that were in effect before that, and that was why you chose to make it non-conforming and what we could do to fix that.
The fact that specific development regulations were in effect before 2021 isn't the reason why we, arrived at the determination that it was non-conforming, unlawful. It was all the evidence stacked up. That just being one of the pieces of evidence.
Agreed. But did we explain to him that, some of these things did go before 2021, were in effect, and that he needed to clean that up and take that into consideration?
And as
deal with
much
it
as we
before-
addressed the access, I mean, and the well permit, I mean, we essentially, indicated that there were things that were in effect before 2021, both those being, an example, and the septic regulations, those were all in effect well before, apart from the specific development regulations. So we probably also included specific development regulations were in effect as well. Do you have any comment
Also,
on that?
just for clarity, we did have two meetings, and the meeting purposes were to advise him of what was discovered, what was in place. And one meeting was on 3/20/25. And that was the first meeting with the property owners, investors. We had a secondary meeting in October of 2025 with the investors who were stated they were here on his behalf as well, to again restate and go through solutions and what we could do to get them permitted. So we had two meetings advising of everything, and what, again, each meeting ended with us saying, here's an application, put in your application and let us help you get permitted. So both meetings, that was addressed and identified.
Okay, so then Mr. Austin didn't follow up by filling out the forms, is
We
that?
still do not have an application.
Okay, all right. Anyone else?
Staff.
Not this time. Okay, public comment. Can I get the, oh,
Do you want to have the applicant?
Yeah.
oh, yes.
The applicant needs to.
Yes, is the applicant here and would the applicant like to speak?
Thank you.
Yes.
Okay,
And his lawyer's on Zoom or whatever that is.
This is Tag Moss. I just wanted to acknowledge my presence.
My name's Tim Austin. I'm the owner of Fort Austin. I have one of my investors here that would like to make a statement. And I'd like for him to come forward if that's acceptable. I'm sorry. Is that better? Can you guys hear? Okay. I'd like him to come forward for just a moment to make a statement, and then I will, I have a presentation to make also then. Is that okay?
Yeah.
Okay.
Okay, can you guys hear me? Yeah. Okay, so I'm Paul Devlin. I've been a Paonia resident since 1998. I live between Paonia and Steamboat. I'm here on behalf of my friend and business partner here, Tim Austin, the owner of Fort Austin, and his partner, Heather O'Rourke, and you'll hear from these guys in just a minute. I'm an investor in Fort Austin, and I've been part of the project from the beginning, which was 2014. It's been a lot of fun until about a year ago, when Delta County first started what I would describe as harassing Tim and accusing him of illegal and non-compliant activity, which then pushed him into a new problem with the state of Colorado over this intergovernmental agreement known as an IGA, where he now faces really an absurd multi-$100,000 potential liability. And we're going to show you tonight how even the county is supposed to initiate enforcement actions like this only based on a formal complaint process from a citizen, that no such complaint was ever issued against Fort Austin. There is no such document trail. Furthermore, the county failed in its own written protocol outlined in the 2024 land use codes. But first, I just want to start by vouching for Tim. He's a family man. I know him as a true man of his word. He's a former state champion wrestler here in Colorado, a former successful general contractor. My experiences of Tim is whenever he does something, he does it right or not at all. So I knew Tim would build Fort Austin right. That's why I invested in the project. So I want you to keep in mind that this is the guy, along with his amazing partner, Heather, you're going to hear from here in a minute, that Delta County has pushed to the brink here. I've watched him drain his savings, deal with massive personal stress, and spend hundreds of hours wrestling with how to respond and react to all of this. And it was all initiated on false pretenses. Stress like this does damage to people. And that makes me angry because it's totally unnecessary. As the evidence clearly shows, the whole thing was predicated on a fake complaint form. So here's my first message to Delta County. Tim Austin and Heather O'Rourke are exactly the kind of people you want to attract to the county, not drive away unnecessarily. But because of all this, we are already planning a potential exit should this, what I consider an unlawful government harassment, continue. So that means Tim and Heather, who you're going to hear from here, may simply just sell Fort Austin as a trophy property to the highest bidder, then take their cash and go redeploy their skills to some other county in America that actually wants their business. Most likely, the buyer of Fort Austin will be some wealthy family from the Roaring Fork Valley who will come over here. They'll have it as a private retreat, so the place will sit empty most of the year, and all the revenue generation, community benefits, all the benefits of Fort Austin simply go away. And in the end, Delta County is the loser. In fact, there are actually no possible winners emerging from any of this. I make my living as an investor. I look for places I love to deploy new capital. I love this valley. It's at the very top of my list of places. But after watching all of this take place over the past year, it gives me serious pause. I mean, I have new capital to deploy, and why would I put it here and deal with hassles from the county planning department? If you guys want the perfect plan for driving capital away from the county, this is it. You guys have figured it out. And I hope you will reverse course here and give me some hope. You know, give me a reason to stay here and invest here. I've already invested millions of dollars since I first moved here in '98, and I'd like to deploy more here, but I don't think I want to based on how this has all gone. I've now heard of 2 recent multi-million-dollar real estate transactions that were abandoned by the purchasers when they discovered all the potential regulatory risk they might have to face from this county and this planning department. So my question is that really the climate you want to create here? Word spreads so fast these days, you can't avoid it. And so it gets out there, and buyers who want to come in and expand the county and open businesses and participate in Delta County in a new way are turned away by that. They're turned off by that. So when you guys are voting tonight, I hope you'll keep all of this in mind. Without business creators and investors like Tim and Heather, towns languish and fall apart. Opportunities for growth are lost. We don't want to drive away the very people whose efforts help fund the government. We don't want to drive away someone successfully promoting agritourism, which is the true category that this property, they create a binary choice that it's either a residence or it's commercial industrial. No, it's agritourism. It's an ag property where people come to experience agriculture, and there's lodging, and there's a precedent for that in the state of Colorado. It's not a binary choice between residential or commercial. Tim has a 4.9 user rating for his visitors at Fort Austin. So apparently people come and they love it, and they indicate it clearly in their reviews. So Tim, as the owner, he knows that he's in jeopardy for bad reviews if guests feel unsafe, if the place is dirty, if there's safety issues. So the free market drives him to give people the experience they want so that he can maintain, 4.9 or a 5.0, so people will keep coming back. And that's why most of these regulatory schemes initiated by well-meaning government people are almost completely unnecessary in this world, especially when pushed to this degree. So in the matter of Delta County versus Fort Austin, it's abundantly clear that the county has implemented an enforcement action in the spirit of selective enforcement and through the use of false and manipulative tactics. We can do better than this here. Delta County fails here at even the most basic tests. They didn't follow their own protocol as written in the 2024 land use codes. Not only did they base their enforcement claim on a clearly manipulated complaint form that Tim will cover here in a minute, but they never even followed up the complaint with a field visit, which is supposed to happen within 30 days as their own enforcement procedure requires. So why are we even talking about this? Why have Tim and Heather and other agritourism operators in this corridor and in the valley been forced to waste their productive time fighting all of this? It's crazy, and it needs to stop. Fortunately, you guys at the BOA have a chance to put a stop to it tonight, and I honestly hope you will. I'd like to address this IGA agreement quickly. When Tim purchased Fort Austin, we did a title search, and nowhere did the IGA agreement with Colorado come up as a potential liability, okay? This is pure negligence on behalf of Delta County. In the IGA, the state has told Delta County that Tim's property and other properties on 133 may face, again, a multi-$100,000 liability, which Delicious Orchards, after the accident occurred there with poor Casey Gillenwater, a friend of our family. So what happened there was they had Delicious Orchards had to incur this massive liability to add turn lanes into the property. But it isn't recorded properly by the county. So the address and the legal description was not included in the recording of the IGA. So our title company, when we were looking at making this investment in the property, was unable to locate this IGA. Had we known about this potential liability, like we might be charged with having to add turn lanes and at our own cost and do all of this, we never would have purchased this property. So Tim and I made this investment not knowing that an existing agreement between Colorado and Delta County will likely force Tim to fund some kind of entrance change or lanes or whatever it turns out to be. None of this was public knowledge, and it was not discoverable in any way by the public. Okay, the county cannot encumber future property owners with that kind of potential future liability without properly informing them via the recording of documents in the public record. If it went to court, in my opinion, I'm not an attorney, Delta County would lose. I know this has nothing to do with the director, as this IGA agreement was before his time. I'm not making that claim, but these are the unintended consequences of excessive government regulation and overreach. Was the government pushed by his bosses to show that some new effort was finally being made to rectify this neglected agreement with Colorado? We have no way of knowing what actually happened, but this is not right. One final point, when a county attempts to implement new restrictive land use codes, especially in a rural county like Delta County where they barely even implement basic building codes, that county ought to be tripping over itself with friendly grandfathering and stair-stepping existing property owners slowly in the direction of compliance. Not aggressively enforcing new codes and engaging in gotcha tactics against existing owners who built businesses way before any of these codes were ever in place. And that's what's taken place here. It's been gotcha tactics. Take a look at the complaint form. You'll see exactly what I'm talking about. So public outcry here is loud and clear. 2,200 signatures prove it. Fort Austin has been harmed financially and in other ways for no reason and for no public benefit. Harm has been done. No safety gains have been achieved. No residents have been helped. No visitors to Fort Austin have benefited in any way whatsoever. And yet here we are spinning our wheels, taking all this time, coming to this meeting, right? And there's no fundamental legal basis to begin with. There's not a proper complaint form, which is their very own criteria for how this is even supposed to start. So I just hope you guys will do the right thing tonight and put a stop to this. I know you're all volunteers. I really appreciate your time and thank you so much for listening.
Can you hear me?
Yep.
My name is Heather O'Rourke and I live at 41339 Highway 133 in Paonia. I come from 3 generations of farmers in northern Maine. Farming wasn't just our livelihood, it was our identity. It taught us responsibility, humility, and respect for the land. 25 years ago, I chose Paonia because it carried that same spirit. I wanted to raise my children somewhere the land and community still mattered, where agriculture wasn't something you talked about, it was something you lived. Fort Austin is our legacy. It didn't arrive overnight. It was built year by year, season by season, with sacrifice and intention. It carries our family's story and the future we hope to leave our children and grandchildren. Tim and I built Fort Austin with our own hands and our own savings. It has always been hard work, but it has always been a labor of love. We created our agritourism location to support local businesses. And in 2018, we're excited to see that Delta County created the 2018 master plan that supported exactly what we have been doing. For years, guests have experienced real agricultural life here at Fort Austin and in this valley. They watch us gather fresh eggs while the chickens proudly announce their work. They see us tend the garden, the orchard, the land. They hear the coal train whistle echo through the valley. They visit local farms, wineries, and small businesses. But they don't just watch, they learn. They learn where their food comes from. They learn patience, responsibility, and the value of one's land. They learn that agriculture is not an idea, it's daily work, stewardship, and care. Our guests look around and tell us how rare this valley is and how they wish they could live a life like this, where land, work, and community still belong together. That is agritourism at its most genuine. It keeps land productive, it supports farmers and ranchers, and it protects a way of life that is disappearing everywhere. But this last year has taken more from us than I can fully put into words. If we had known that rules would be applied retroactively, rules that did not exist when Fort Austin was built, we never would have invested our life savings here. Instead of caring for the land and our guests, We have spent thousands of hours digging through records, researching law, and fighting to prove that what should have been recognized all along as legal nonconforming use. When we were targeted by a so-called complaint, no one from the planning department came to see our land. No one tried to understand what we actually do. After months of working with the county and asking for our legal nonconforming use to be honored, we were simply labeled unlawful. I felt isolated, I felt afraid, and for the first time, I wondered whether there was still a place for families like ours here. But instead of giving up, we reached out to other targeted agritourism businesses, and we stood together. We told truth, we educated the public, and the response was overwhelming. Over 2,200 signatures from this county and beyond, because people know what is at stake. What breaks my heart is how many others are now afraid. Afraid to speak, afraid to share, afraid to grow, afraid that if they are seen, they will be next. That is how agricultural communities survive. Tonight, you're being asked to decide whether there's a sufficient evidence to label Fort Austin unlawful non-compliant, and whether that decision has made within the planning director's authority. I ask you to pause and consider what that means. A family endeavor built in good faith, a long-standing agricultural use, a way of life that existed before the codes were applied, no complaint, no site visit, no attempt to understand the land or the use, no recognition of what the law calls legal nonconforming, a protection meant for exactly this situation. If long-standing agricultural operation can be declared unlawful without clear, sufficient evidence, without context, without history, without acknowledging legal nonconforming use, then no family operating in good faith is truly safe. This decision will not only define Fort Austin's status, it will define whether fairness, evidence, and lawful authority still guide land use decisions in Delta County. Thank you for your time and truly listening.
Good evening, Chair and members of the board. My name is Tim Austin. I'm here on behalf of Fort Austin and the Austin Family Trust. Thank you for the time and for the work you do. I understand the responsibility you carry, and I want to be very clear about why I'm here tonight. I'm not here asking this board to rewrite the land use code. I'm not here asking for special treatment of any kind. I'm not here asking you to approve a permit or make a policy decision. I'm asking you to decide whether the planning director's determination that Fort Austin is an unlawful, non-conforming use was made with clear and convincing evidence and through the enforcement process required by the code. I respectfully submit that it was not, absolutely not. What this appeal is really about. This appeal turns on three core questions. Was enforcement lawfully initiated as demanded by the Land Use Code of Delta County? Number two, was the required enforcement process followed as outlined in the Land Use Code? Number three, does the record contain clear and convincing evidence that Fort Austin was unlawful at the time its use was established? If the answer to any one of these questions is no, the director's determination cannot stand. How enforcement began and why that matters. Let's start at the beginning because process matters. Under the 2024 Land Use Code, enforcement begins with a complaint, followed by a field visit within 30 days to determine whether an alleged violation has merit. That field visit is not optional. It is how facts are gathered. It is how evidence is discovered. To be valid, a complaint must allege a violation of the Land Use Code. In this case, there was no valid complaint alleging a Land Use Code violation by Fort Austin. The Davises, whose names appear on the complaint form, have stated publicly and on record at both the Planning Commission and the Board of County Commissioner meeting and at a private meeting that they did not intend to file a complaint. That means they certainly didn't file a complaint alleging a land use code violation by Fort Austin. Their concern, as they explained, was that CDOT infrastructure requirements were being imposed on their new venue. They were frustrated about turn lanes. They were frustrated about costs. They were not alleging a violation by Fort Austin. They also stated the planning department staff insisted they fill out a form so the county could investigate and get them answers about CDOT. An expression of frustration about CDOT requirements is not a land use code complaint. Without a valid complaint, enforcement should never have been triggered. Frankly, why are we here right now? CDOT and the source of the complaint. This point is critical. CDOT has stated clearly that they did not initiate highway access reviews without a direct complaint or an accident. In this case, the complaint to CDOT did not come from the public. It came from the Delta County Planning Department itself. That referral was made before any field visit, before any notice to Fort Austin, before any verification of alleged violations. Other state agencies were also contacted before any field inspection occurred. This is not how competent enforcement works. When the government initiates enforcement against a citizen or business, it must follow its own rules. The planning department clearly did not. When they did not follow their own rules, due process is violated. And due process is absolutely necessary. No field visit, no evidence. Even if one assumes, for the sake of argument, that a valid complaint existed, the next required step never happened. There was no field visit as required by the 2024 land use codes. No inspection, no firsthand observation, no measurements, no verification of use, no count of capacity, no observations of the conditions, no inquiry into when Fort Austin was established. Instead, enforcement relied on their own interpretations of website screenshots, online descriptions, test marketing, aerial imagery, assumptions made about use and intensity. That is not evidence gathered through enforcement. That is desk research, not investigation. Process is not a technicality. Process is the evidence. Process is how the facts are gathered. Process is necessary. Without a field visit, the county, by its own legal requirements in their own land use code, cannot meet the clear and convincing standard required to declare a property unlawful and non-conforming. Additionally, when I filed a Colorado Open Records Act request for all complaints against Fort Austin, none were produced. No complaint, no photograph, only an advisory letter issued by the planning department. That request was filed on February 27, 2025, 3 weeks after the date on the photo of the Fort Austin entrance, which has now been added to the complaint recently. No complaint showed up in the CORA request because there was no complaint against Fort Austin. The photo dated February 6 did not show up in the CORA request. Let me remind you, this process cannot be initiated without a complaint. As outlined in their own land use codes, we had not even seen that photo until a week ago when we received the packet from the planning department. Delta County Planning Department decided to add that photo to our complaint. What clear and convincing evidence requires. Clear and convincing evidence is a high standard, and it should be. It requires proof that is directly observed, reliable, verifiable, based on firsthand investigation and knowledge. It requires evidence showing the use was unlawful at the time it was established. There is no evidence on the record that Fort Austin was unlawful when it began in 2014. There's no evidence that a regulatory threshold was crossed after the land use codes were adopted. There's no evidence that the use changed in a way that violated the rules in effect before the land use codes. Instead, the planning director's determination applies rules adopted later and applies them backward in time. That's retroactive enforcement. Fort Austin did not change its use after the land use codes were adopted, period. What changed was Delta County governance. They changed their land use codes. Fort Austin predates the land use code. When Fort Austin began operating, there was no land use code. There was no agritourism permit required under Colorado law. There was no conditional use process in place with the land use codes. There was no application form. That's why the planning director could not furnish an application form. There is no pathway to apply for something that does not exist. In 2017, the county attorney, Jen Hopak, stated in a letter that activities associated with agricultural operations were exempt from specific development review. In a February 2025 email to the current planning director, the former planning director, Elise Ackerman Castleberry, stated that the agricultural activities, including lodging and events, tasting rooms, and farm-to-table dinners, were exempt from specific development review. Before the land use codes, no permitting was required for agricultural use. Agritourism was lawful under Colorado state statutes. It was allowed by right. It was not regulated. No permit forms existed. No permitting process existed. The 2018 Delta County Master Plan explicitly supports agritourism as an economic driver. Agritourism was a developing part of the county's economy. In 2026, the Delta County Land Use Code permitting process cannot be applied retroactive to 2014. By aggressively initiating enforcement against existing Delta County landowners, the Delta County Planning Department has opened Pandora's box. After studying the land use codes, we drive around the county and we see violations on properties everywhere. What about your property? Is it in perfect compliance? The violations I just mentioned that I observed were in place long before the land use codes were adopted. How is this retroactive enforcement damage? How will this retroactive enforcement damage landowners all over Delta County? Existing uses must be grandfathered in. The water rights impacts. The Delta County Planning Department's determination repeatedly deems Fort Austin to be commercial, not agritourism. If this determination stands, we will be required to reclassify our well. This change will reduce our well allotment from 1 acre-foot of water per year to 1/3 acre-foot. In addition, it will require an exorbitantly expensive water augmentation plan. Fort Austin's well water usage has never exceeded our allotment. And you have seen the calculations on our well use. And it has never provided water for more than the equivalent of 3 residences. We were very conscientious about never overusing our water rights. This enforcement threatens the viability of the property itself. We will not be able to keep our fruit trees and grapevines alive after the Fire Mountain Canal flow ceases. This will jeopardize our agricultural production and thus our agricultural status. If enforcement can be initiated without a valid complaint, without a field visit, based on assumptions rather than inspections, and initiated long after the fact, no long-standing agritourism or agricultural operation in this county is safe. What I'm asking the board to do, I'm not asking for special favors, but I also don't want to be singled out anymore. I'm not asking you to bend the rules, but I also don't want to be targeted. I'm not asking you to make policy, but I also don't want to undergo selective enforcement. I'm not asking you to block future enforcement if we do change our use. I'm asking you to simply uphold the law as outlined in the Delta County Land Use Codes. I'm asking you to do exactly what the code authorizes you to do, to find the director's determination was issued without clear and convincing evidence through a procedurally defective enforcement process, and reverse his decision. Doing so does not weaken the county's authority. It strengthens the rule of law. In closing, Fort Austin has always acted in good faith. We designed every element of that property to provide safety and quiet enjoyment for our guests. We designed and built the property to use, but never overuse resources and public infrastructure. We use less well water than allotted. We efficiently use our irrigation water, ensure that it doesn't affect our neighbors. We monitor noise levels at every event and ensure they never exceed state mandates. We do not use herbicides or pesticides. Our driveway traffic volume is a fraction of what it was when Colorado Westmoreland Coal Company owned the property. We provide fire safety and emergency preparedness. We have no junk piles and comply with all rubbish ordinances. We interact with neighbors to ensure peace and tranquility in the area. We support the wineries and galleries and shops and restaurants and events in the valley. We purchase products locally to support businesses and the tax base that our guests do the same. We've made every effort to be a bright spot in this county. Yet I've had to cash in my retirement to defend myself in a process where my own tax dollars are funding the enforcement staff sitting here right now, the county attorneys sitting here right now, my own attorney, and the appeal fees. All I ask is the law be applied as written with due process, consistency, and respect for longstanding operations that should have been grandfathered in from the start. Because of what the planning department has done, everyone loses. Fort Austin has been severely damaged financially and in other incalculable ways. Fort Austin now faces a potential multi-$100,000 liability with CDOT, all stemming from a fraudulent complaint. Public trust of the planning department has been destroyed. Delta County government looks inept and vicious toward Delta County citizens. Nobody here wins, but we're imploring you to stop the damage to Fort Austin. Stop the damage to our county. Please overturn the entirety of the planning director's determination. Declare Fort Austin legal non-conforming. Halt all code enforcement against Fort Austin. Thank you for your time and your service and your consideration.
Your attorney going to speak at all?
If you have questions, I think he would rather have you ask the questions and then he will speak after that, but he may speak for himself. He may want to do that.
Can we make him bigger so we can see him?
Everyone.
There we go. Okay, cool.
Hey, I wanted to open up the floor first to your constituents. Given that they're the most affected, I wanted to give them a platform to speak. And if the Board of Adjustment has any time at the end, I would like to respond to a couple of Mr. Gardner's comments. However, I just didn't want to take any time of the people who are there today in that room there to speak.
Can you turn it up?
Thank you for being mindful of that.
It's as loud as it can go.
Yeah, that's as loud as it gets, folks, on the interwebs. Can we take a quick recess before we start public comment, just so I can powder my nose?
Sure.
Sorry. All right, so do I just, yeah, 5 minutes? Does that work for everyone? Okay, thank you.
Yeah, yeah, I agree.
Guys, let's sit down and
Please
get
have a
this
seat.
going.
All right, we are going to resume. Everyone ready? All right, thank you. Okay, at this time, board members, do you have any comments for the applicant?
I have some questions, but I'll let you.
Comments, questions?
Yeah, go ahead, Mike.
Yes, I have a question for the applicant. What I'm reading here in our packets and your presentation, which is very good, I thought, and very well thought out. There seems to be some disconnect for information that's been given to us.
Okay.
You state that there was no complaint. And in our packet, there was not only a complaint of some form, but there was also a follow-up complaint. So I don't understand the logistics of the formal complaint or not, but are you saying that none of that happened? Are you saying that technically?
I'm not saying none of that happened. What I'm saying is that the complaint form is completely fraudulent. Let me point out some information here. I'll give any of you $100 bill right now if you can take this form and tell me what the Fort Austin complaint is based on this form.
You have that form
Okay.
in front of you?
Yep, we've got that.
I've seen it, both of them, yeah.
$100 bill on the line. Can you tell me what the Fort Austin complaint is?
Okay,
All right.
I see your.
I'm
your
not giving up a
point.
$100 bill, doesn't sound like.
I'm
Okay.
just,
A couple other things is detailed description of a complaint. Describe the nature of your complaint. Please print clearly. If you require more space, you may attach additional sheets. So the nature of their complaint is the barn at Howard Creek Farm, Crawford, Colorado, Zinzin.
That's perfectly clear.
Yeah.
Everybody knows what the complaint
We
is
need,
now,
I
don't you?
need questions or responses only from the applicant at this point. No public commentary.
okay, that's, yeah.
Okay, and then let's don't stop there. Look at the Zinzin, how that's filled in. And then look down at the signature of the code enforcement officer. Look at the E's. And then we have, well, he can admit it or not. He might want to admit it or he might deny it. But he filled in Zinzin after the fact. After this form was initiated by Mrs. Davis, she saw this and said, well, I didn't fill that in. And then the code enforcement officer, we actually have him on tape admitting it. So he's not going to look up and he's not going to admit it, are you? Okay, there we go.
You're addressing us at this
Yeah,
point,
please.
so.
Okay, it's already, okay, so,
You're answering my question, I guess, to you.
okay, I don't know what to tell you. This is, it's silly. It's not funny, but it's ridiculous is what I'm, and Sageview Ranch is listed on here, but Fort Austin's not even listed on here. And then there appears a photo last week in my packet that the planning department suddenly decided to include. We had never seen that. It didn't show up in a CORA request back in February, in the end of February. And they are admitting that they had possession of that photograph starting February 6th, and it didn't show up in our CORA request. So somewhere along the line, they included in the packet, but we'd never seen that.
What photo are you referencing
The photo of Fort Austin, the entrance to Fort Austin.
with the
That's in
complaint?
It's in the packet?
With the
It's in the packet.
acceleration
Yes, it
lane in
is.
it, yeah.
Okay.
Yes, and that's the first time I'd seen it.
And that was in section or attachment 1, I believe, right? In our packet, is that picture of the front? There it is.
And that shows the acceleration lane that at some point had been put in.
Yep. You're
Over
referring
south end.
to this one that's in the packet?
Yes, sir. I'd never seen that.
Yeah.
Yes, sir. And by the way, Mr. Tromley, I'd like to thank you. You are the first person from the county to show up at my property. I appreciate that. I have respect for that. I really do. The planning department didn't bother. They didn't bother.
Okay, well, thank you for that. I know we're gonna go through a process here that's really giving me some indigestion over, my neighbors and fellow citizens here. But just before we get sidetracked, if there's any way possible for you to fill out some of their applications in the county that exist, to obtain and bring you up to not the land use code per se, but the code previous. I would definitely like to see you do that. And when I was at your property the other day, I parked right in your driveway. That's why I introduced myself
Sure. Oh,
and
yeah.
apologized for
No apology
cutting
necessary at
your
all.
road off. But I see in this picture something very similar down the highway. My wife and I try to go to a lot of these different venues and whatnot. And Big B's is one we've done half a dozen
Yes, sir.
times in the last few years. And if you look at Big B's access off
Yes, sir.
of the same highway, and you look at the 3 lanes there,
Yes, sir.
the only difference that I see, and I didn't put a tape measure to it, but the only difference that stands out is the paint.
Yes, sir.
So you've
Yep.
already got 3 lanes. If you were to change how the highway is painted and have the travel through lane, maybe stay in the center or something, I would fight that with the state. Well, the end of time, I think.
Yes, sir.
I think you've got
Yes, sir.
You've got a
And-
good argument there, and I don't want to see you feel like you're
Yes, sir.
being pushed out or anything, but there are, that's not in our control. It is obviously in CDOT's control, what they do with it is besides the point.
Yes, sir.
And-
And I don't have, I don't have control of that, so.
But if I was in the position of working in the planning department and I had to go look something up to see if somebody was in violation without making the landowner angry, for a nice way to put it, I would start with the access, the water, because what you're doing, and this is not the first one in the last 2 years where a venue has been proposed and didn't have adequate water. And we've recommended to the applicant, to consider cisterns, or there's all kinds of ways to get adequate water without coming up
Can
with
I
an
answer,
augmentation
can I answer
plan.
that? At the moment, I have adequate water. Because of what the Delta County Planning Department has done to me, turning me into the DNR, they're gonna take 2/3 of my water.
If they
That's
make
what
you
this is gonna
change.
be, because they
Correct.
determined that I'm commercial. We're agritourism. We stood on agritourism. We depended on agritourism. The county never said anything to us till this fraudulent complaint showed up. I have adequate water. That's what I'm telling you. The minute they take away my water, now you and I are gonna have to go find some other source of water. What's that gonna be? It's gonna be an expensive augmentation plan. Right now, I have plenty of water. We've never overused our water. In fact, the calculations I showed you guys, those are high estimates for what we actually use. We showed about 61%. It's probably quite a bit less than 40% of our water that we use out of that water. That's our allotment of 1 acre foot. But now that the county has done what they've done, I'm gonna lose 2/3 of my water rights.
Yep, I understand
Yeah,
your thought
yeah.
there. And I guess the last thing that without getting up off of a desk and doing anything more, your septic system. I was made a reference that you were a builder.
Yes, sir.
Okay, so I've done the same thing since the mid-80s. Put in lots of septic systems in Delta County. got regulated out of it because I just didn't want to do it anymore. And I didn't want to keep up with the new regulations and whatnot. But
Sure.
I had over 20 to 25 years of doing that. This septic system that was put in, no permit was pulled for it.
Oh, I don't know. When I moved in, okay, so
No,
let me,
the one for the cabins, the second one that they make reference to here, Sam's been
Oh.
out to.
if they'd have bothered to do a
Okay.
field visit, they'd know there's no septic system for those cabins. There's no water in those cabins. They didn't bother.
Okay,
But what about the bathhouse and all that?
The bathhouse has water to it. Yes, ma'am.
Okay.
Yes, and that is tied into that septic system. When I bought the property, so this, let me explain a little bit about this property. There's things that go on that have gone on this property that I don't get it. So I've got two concrete cisterns, 5,000 gallon cisterns buried at the top corner of my property. I have no idea who put them in or when. I've got concrete foundation sections that are more than 2 feet wide. Why would someone do that? I think the reason they engineered such a huge septic system, there's a tub in that house that holds over, let's see, it's 7 feet long by 4 feet deep by 4 feet wide. It had three water heaters. We took them, we only need one, but we took the other ones out. I mean, who does that? Well, Westmoreland Coal apparently did that. I can't, why would they engineer a system that big? Why would they put a tub in that's 7 feet long by 4 feet? I don't know. I don't know, but this property there's certain elements are way overdone, so,
right.
yeah, I don't know what to say.
Yeah.
Right,
well,
Yeah.
I just want some clarification
Yes, sir.
to understand what you're thinking, and I think I know pretty well what the planning department, their thoughts are on it, so
Yeah, okay.
thank you for your answer.
You bet.
Appreciate it.
You can go ahead.
Any follow-up?
I have no questions, but go ahead.
You can go ahead.
Oh, okay. Kim, so, due diligence, back when you bought the property, you didn't know about a lot of the stuff, but, are you willing to bring it up to what the code was then, i.e. water, all of those things? And I think you can, I would suggest strongly that they, the county could advocate for an egress from, Garvin Mesa Road instead of the highway. Yes, Sean?
The access will really be determined by a traffic study
Mhm.
by a traffic engineer. And then what's permissible off of the highway will be determined by CDOT. What's permissible by the county off of the county road, Garvin Mesa, will be determined by county engineering. I can't necessarily say what that could be. CDOT could say that they could move their access down, further to the other side of the property.
Mhm.
They could say that you have to come in off of Garvin Mesa if that's possible. It may not be possible.
Well, in that picture, there's clearly an acceleration lane going southbound, so, yeah.
There's a utility structure on Garvin Mesa. There's a lot to look at and think through. And I don't have the answer to what the solution is. That's what the process is for, is to determine how to do it safely. It's right, their access is right next to Garvin Mesa Road, so.
Mhm.
I can try to answer that question, but I may need more clarification on what you are asking. Garvin Mesa Road, that is not an option. We have a barn, and then TDS has a phone pedestal where they have the gravel pad, and our driveway would be maybe 14 feet wide. We can't get trailers in and out. I've got a 20-foot flatbed trailer that I haul periodically. Can't get that in and out of there. And there's drainage that would make it impossible. We'd have to, because of topography, we'd probably have to move 400 plus cubic yards of material just to get a driveway cut in there that would work. It's really not and then line of sight. Looking up Garvin Mesa, you'd have less than 100 feet of line of sight, which let me go back to the CDOT specs also. CDOT specs, from my understanding, take a call for 200 feet. You cannot have a driveway within 200 feet of an intersection. We're talking 80 feet maybe from a stop sign there, something like that. It's not really practical. And let me answer it a different way, maybe. This might help. This might be what you're asking. Colorado Westmoreland owned this property, and you may have seen in the packet a letter from John Morrell. John was a service superintendent for 2 decades or whatever at Colorado Westmoreland. My driveway, my property was used by corporate executives. So they would do short-term stays, they had office space, they had meetings, they had gatherings, they had parties, they had all kinds of equipment storage, all kinds of things went on that property. At that time, John said, oh yeah, there was more than 60 vehicles in and out of there every day. Okay. We've never had that. Never, not one day in the existence of Fort Austin has there been 60 vehicles in and out of that property. So that might help clarify. Also, that section of highway, now I'm talking about the driveways across the highway, but that 100-yard section of highway, John, I told him, I said, John, somewhere along the line, I worked underground at Westmoreland. That's how I went to college. And if somewhere picked up that dumps, the belly dump trucks, semi trucks, 30-ton trucks, it was designed for 350 trucks per day. And John corrected me. He said, oh no, there were 500 trucks a day when they were running 2 shifts, which was certain times of the year and that sort of thing. So that section, and 0 accidents, 0 in 20 some years. And so that sounds to me like a pretty safe section of highway. That sounds like, to me, like we don't use near that level. We'll never have that level of traffic in that driveway.
Well, knowing where the complaints came from, and I thoroughly disagree that the planning commission would have accepted them from the Davises, because this was clearly a way to try to either make all the rest of you that had these event centers suffer as much as they were, which was absolutely wrong. I asked Mrs. Davis herself, because she was looking for me in town. 11 times she came into my store looking for me. I finally called her back. And she wanted to know why everybody hated them.
Yeah.
I gave her the reasons, but I won't go into those now.
Yeah.
But I find it, I want you to work with us, with the county. Try again. I think you can make it work, but you have to be willing to give and take a little bit. Even if it's just getting the water to where it's compliant with the state of Colorado. You said something about the bathhouse being on the same system. Was that it? That's not considered residential use.
Well, when I in my statement, when I say that we've never used more than the equivalent of 3 residences hooked up to that well. Here's let me define that a little bit. We've got the main house, we've got the cabin, and then we've got a bathhouse that has 2 bathrooms in it. Well, those 2 bathrooms serve 5 cabins. So you say, well, that's 10 bedrooms. Well, hold on just a minute. Those cabins are only open half of the year. So now they're down to 2.5 bedrooms, right? And then our occupancy rate is roughly 20% or less. So now you're down to a half of a bedroom that grain bin bathroom supplies water to. And so that's why we don't use a ton of water. We use, frankly, I think on our calculation, you guys have that, but on our orchards, we have to sprinkle those after Fire Mountain Canal water is shut off. And we use quite a bit on just the ag land, just keeping the trees alive. They're new trees, and then we're getting ready to put in grapevines. And so it'll take 2 or 3 years that we have to water after the canal ceases. But here's you're asking me to do that, and I don't mean to be argumentative. You're asking me to go back into a system of people that don't mind at all. They don't mind at all forging things. That's a sign.
All right, we're gonna take a quick
So
break
anyway,
while we figure this out. Hold that thought. What is that? You are, where's Miss Kay?
Back where she's outside.
Okay, I'm gonna go get everybody lined up. I know it's pretty. I just we like something towards it before we follow right.
Yeah, you just have to get
You're getting cold.
I thought it's like, wait, what?
It blows right here. It's really hot.
It's like, you know, my head. Okay, Tim's fault.
If everyone can come sit down, is everyone awake now? Yeah, not cold. Sorry about that. Who done it? I'm just kidding.
So Tim, continuing with.
Wait a
this-
sec, hold on. Brittany, are you ready? Okay,
Tim, continuing questions, about the well. We don't have any choice about. It was, permitted for households. The bathhouse would be a state designation, and I don't believe that they would consider that, but that's something that you need to deal with them. It would not fall under the household use kind of thing. Is there a way you can work that through
Well,
without using the well? What I'm trying to come up with here is, can we come to an agreement on, some of the things that they're complaining about, irrespective of who made the complaint, but the ones that would get you in compliance with SDR and whatever you may have done afterward. Are you willing to do that, is what I'm asking.
the answer is I don't know. Because I don't know what that means. If the planning department had done their job, we wouldn't be sitting here. We wouldn't be sitting here if they'd have just done what the code requires them to do. In other words, let's say they had come to us and we'd kind of worked these things out and figured these things out. Well, they would not have reported anything to the Water Commission yet. We'd still be working this out, trying to figure this out, but they put us in this position. So they put us in a catch-22, just like they've done maybe with the Highway Department. We don't know yet. But we don't have an option of going out on Garvin Mesa, not to meet, if it won't meet specs anyway.
Have you contacted CDOT to
what's
see,
that? I'm sorry?
have you contacted CDOT?
We have, and we talked to four different traffic engineers also.
And you've done the traffic survey?
No, ma'am, I can't afford to do this. I mean, I've cashed in my retirement account to fight this stuff off.
I get this.
And
I
I would.
really do, yeah.
And so, no, ma'am, I have not paid for that yet. Eventually, I don't know what we're gonna do.
What I'm trying to do is get this to a point where we can get you in compliance if you're willing to, so you can operate your business.
Okay.
I mean, yes, it's
Let me-
probably going to cost you a little bit of money, but
Okay, let me.
every business costs money to
Okay,
start,
yeah.
yeah.
I'm glad to address that to a degree. If they are going to deem me commercial, I can't do it. They're gonna bankrupt me. If they are going to cause me to have to spend, $500,000 on the highway, I can't do it. I'm gonna go bankrupt. So when you ask me to comply, I'd like to comply, but we're talking about people that you're gonna make me work with people that will forge documents and not follow their own codes and not even consider, I mean, they have never had not one word of discussion with me about grandfathering, what that might look like. And by the way, a lot of the pictures you saw that they are using for evidence against me are flat out false evidence. Sitting in this room is a person who planned an event for July 1 in 2021. And if you'd like her to, I'll invite Amy up here. She will explain to you that every single cabin was there. And they set their bar on the deck of the last cabin because I hadn't gotten the logs stacked on that. The pictures he showed you, he's cherry picking data, and he's not being honest with you on the. And when we came in here on March 20 for a meeting, they flashed a picture on the screen that showed all of the units in place in 2021. He's not showing you that picture. He's not bothering to do that.
No, we've seen the aerial photo of that.
Well, okay, but
Yeah.
look at the dates on those. And they're trying to make it look like we didn't have this stuff done. But Amy Pipes can tell you that everything was done on July 1st. Now, I'm a pretty good builder, but I can't build, what would that be, 3 cabins in 6 months or whatever that would be. And one thing about the aerial photos, you saw a different set of aerial photos that I furnished. And let me explain, and I'm not an expert on this, so please realize I'm doing the best I can here. Wilmore, the surveying company, I had mine certified because I wanted to make it clear that I'm doing the best I can to get accurate information. What they explained to me is this satellite photo, it's really aerial imaging is where most of it comes from. They do flyovers. When they get these flyovers done, they'll fly for a week and they go back and they download all the data. They stitch all the photography together. They make it to where people can download and understand that. So when they fly over, it takes some weeks, 6 to 8 weeks, 3 months, whatever. So the dates on these aerial photos, be careful trusting those. And I'm talking about photos on the ground. That's what I'm talking about. And here's another thing I'd like to do too, if I might. Can you have maybe the planning director look up in the 2021 land use code? They keep talking about intensification. Could you have him look up and read the section on intensification in 2021 land use code for me real quick?
John, I don't think we have access to that right now. Yeah.
It'll be
We'll
quick.
keep talking.
It'll
Okay.
be quick. It's a
So
trick
what
question.
what I'm getting at is, if you're willing to work with us, we're willing to work with you. But consider that there are some things that we cannot change. The well water thing with the going to the bath, that is the well people in Colorado. That we can't make a determination on that. It would appear to be commercial. I'm not quite sure about the agritourism part, if it could be exempt. I don't know.
Okay,
But
all due
that
respect.
answer needs to be
Okay.
answered, yeah.
All due respect, first of all, would you read the section on intensification on the 2021 land use code, please? It doesn't exist. And you keep accusing me of intensification. It is not even in your code. That's the trick question. Okay, so let's stop using intensification. Let's stop accusing people of intensifying stuff when it's not in your code.
The word intensification describe the change of use from one home to a lodge, 5 cabins, and a pavilion, and events. That's an intensification.
Everything we did was by right. That's the point. We should not even be here. I'm sorry, Ms. That was, the answer is, we came here to determine, Mr. Gardner even said earlier, yes or no. Did he follow the rules or not? We are going to have to deal with that. Please, I don't want you to take this as disrespect at all. We are going to have to deal with that, but I don't know what to tell you because of what they've done to us. They put us in this catch-22 where with our entrance, we can't go on Garvin Mesa. We can't keep our entrance. We can't move it. We can't afford to put in turn lanes. We're in a catch-22 here.
Well, I kind of think outside the box.
I do too.
I looked at that aerial photo and I'm wondering if there's not a way that you could make a driveway access through there off Garvin Mesa, so there would not be an issue.
It'll
I
be
don't know.
massively expensive.
I mean, I know where you are, but I didn't go and particularly look at that, but that thought, and that would take away, hopefully, a lot of the CDOT stuff. I guess my main question to you is if you are willing to work with the county. I mean, I know you've got bad blood going back, and I would also say that I totally agree. And not on Sean, but we've had disorganization in the planning commission for quite a while. So there's been inconsistencies. We want to help you. It is not our goal to put you out of business. Delta County, nor our planning, nor our committee here. But you have to agree to work with us and try to mediate some of the things that we found that needed to be upgraded. We need to find out about the water and mitigate that. We're creative enough in this planning department. I believe that they can come up with something like that, or the state can tell you, maybe you can haul water to it. But as a household use, I don't know. I'd need a lawyer to tell me, or maybe John, or yeah. I don't believe you can, well, you'd probably need to adjudicate the bathhouse if you wanted to use it because I believe that we're considering it commercial because you're renting it to guests. Yes, it's agritourism, but there's that fine line. All right. What I'm asking you is if you are willing to work with this so we can make it work, all of it. And we all just start with maybe a blank slate and we try to fix some of the things that we're out of compliance on. And
I don't know how we can do that. I'm so sorry.
Okay.
We're in a spot here with you're sending me to work with people that are so they're not how devoid of character do you have to be to alter an official document? And then, the way I look at this is when the code enforcer comes in with this complaint form, I've got a complaint form, and slides it across the desk to his boss. Why didn't his boss slide it back and say, no, we don't do this to Delta County people. We don't
quite
do
frankly,
this.
I saw both those complaint forms and I was involved in the Davis thing. And I think this is merely retaliatory on their part. And I don't believe that the complaint should have been taken based
That's where I
upon
agree with
that.
you.
However, we are here and we need to address some issues with your place now that it's been brought to our attention, sadly.
Okay, so I'm now $25,000 down on this thing, and I'm nowhere near getting this solved.
I wish we could have done this differently. I truly do, because
that's
we
why
all
I'm
knew
asking
that
you. I'm imploring you. Deny his determination. Just please. It's wrong what he did. It's wrong the way he approached it. It's wrong everything they've done.
Who?
The planning department with the complaints and they've never come to my site. They've never asked me a respectful question. When we came in here on March 20th, they sat here and it was like the Spanish Inquisition. I'm thrilled they didn't have a water board. They'd had me waterboarded to try to get information out of me. They came at me with, well, we saw the word tent on your website, so that means you're a campground. Well, yeah, we don't have tents. Well, then we saw a van, a conversion van. That means you're an RV. Well, we don't have RV hookups. Well, then you're lodging. Well, no, our cabins don't have water and bathrooms inside. Well, then you're an event center. Well, we kind of do that too. We do all this stuff a little bit. We're a hybrid property, and we're agriculture, we're agritourism. If they're willing to acknowledge that and stop with the commercial, then maybe we can come to some agreement. Maybe we can come to something that everybody can work with. But until they acknowledge that this is agritourism, we did this all by right. Specific development, there's an agriculture exemption in specific development that we should, there's no review process. There was no permits. In agritourism, agriculture, we get the right to do that. Everything we've done is by right.
But some of the issues that we can't control but must enforce is the well water. That needs to be a determination from the state of Colorado. And the access off Highway 133 or access period. I mean, I would think outside the box and see how I could do that off Garvin Mesa Road and it wouldn't be as expensive. Is there something you can move there that, you know?
Very, it's.
Yeah.
Okay.
I'm
The
trying to
answer-
come up with,
Yeah, and I
yeah.
appreciate that. I really
Yeah.
do. I just, I cannot tell you how frustrating this has been. And here's the thing. In that IGA, let me pull the IGA up. The planning director does not have to. Okay, let me read this in the IGA. That was not recorded, that we have never seen until we got well into this process.
Well,
That was Delta
IGA,
County.
quite frankly, I've been doing planning commission for a very long
Do
time.
you understand this better?
I understand, but I also understand that most people don't know what an IGA is and their realtors don't explain it to them.
Okay.
And Paonia is a unique situation. I could go into that, but we've already spent enough time waiting for a fire alarm, so I won't. Yeah.
Okay.
But most
Please.
people don't know about an IGA
Okay.
and that it can affect them.
Absolutely.
Yeah.
And this hit us out of left field. This is not something that we're reacting to this. Delta County failed us. That's what I'm telling you. Delta County failed us. They did not record this IGA with our legal description. They did not record this with our address. It was not discoverable, as Paul Devlin explained.
I don't believe they've ever done that with a
Well-
deed or recorded it. But every town and city in this county has an IGA with the county. It's
Fair enough.
typically a 3-mile radius. I know I've written most of them.
Okay, fair enough. May I read this from the IGA?
Mhm.
Okay. Access modification, any proposed access modification, including but not limited to an addition in access, must be in compliance with this agreement and the current access code design standards unless the agency having jurisdiction approves a design waiver under the waiver subsection of the code. Any access described in this section which requires changes or closure as part of this agreement, or if significant public safety concerns develop, including but not limited to when traffic operations have deteriorated, a documented accident history pattern has occurred, or when consistent complaints are received, may be closed, relocated, or consolidated, turning movements may be restricted, or the access may be brought into conformance with this access control plan. When a formal written request documenting reasons for this change is presented by the agency having jurisdiction, the department concurrence, or in the option of the department, any of the following conditions may occur. The access is determined to be detrimental to the public's health, safety, and welfare. Is my access, Mr. Trombley, you're the only person that's visited my site. Is my access detrimental to public safety, health, and welfare? Would you, just as a general rule, maybe?
I would say it's too narrow.
Okay, but it meets state specs.
It would be very easy, a very easy thing to fix.
Mhm.
You could move that access anywhere along your highway frontage there to pacify.
Okay, so you're saying you're now saying that it is detrimental to public health the way it is then?
If you're asking my opinion, if it's gonna be for what they're gonna term as a commercial use, it's a little skinny.
Okay, I thought we weren't gonna talk about commercial use. Okay, well, we gotta get our terminology here. If, once again, to answer Ms. Kelly's, we can't, if we're gonna have to talk commercial, we're out of business. We're selling the property. We don't have an option. So we're under 50 people. We don't have 50 people at any, we've had over 50 people, once in the whole 8 year, 9, 10, whatever years. I mean, we're talking a small operation here.
But
Okay.
Mr. Austin, your well permit states household use only.
And that's what we do, is household use. That's all we do.
And the bathhouse?
That's household use. That's toilets and sinks and a water heater. So
I think the state needs to determine that, and I would have a problem with that. I don't know that I would consider it commercial, but I think it needs to be argued out by your attorney.
okay.
Yeah,
Well, if it's deemed commercial, we're going to be we're gonna get our 2/3 of our water removed.
well,
Right now, I've got adequate water, but if it's deemed commercial, we're gonna have to go to a commercial well and we're gonna lose 2/3. And that well is producing fine. It's not a problem at all.
now, but they're drying up, so yeah.
Well, yeah, I guess it's possible. So, but yeah.
Just a little point of order.
Mm,
And maybe some clarification here, and maybe the attorneys could chime in.
yeah,
Commercial use is a determination that the assessors make for
Mhm.
assessing tax to a property, and there's rules that go by for that.
I'm
nothing
talking
to-
about the
Has
water.
nothing to do
yeah.
with our assessment or our categorization or classification of the property. When somebody comes in for a land use permit to the planning department, we have to decide what the use is based upon what they propose.
Mhm.
And then we determine where it falls according to what they're proposing. In the case of, Fort Austin, had they come in during the specific development regulation time, somebody in the planning department should have assessed the plan for all the lodging and the events and said, that's a commercial use. And had he come in at that time during specific development regulations, we would have reviewed the highway access with them, the well permit with them, and advised him to talk to those regulatory agencies to get those permits that he needs for the use as they would determine it, not as we would determine it.
Mhm.
Does the Division of Water Resources determine that his property is commercial use? Then they will require a commercial use well permit.
Right.
Does CDOT consider his property commercial use? Then they will determine that and they will require a commercial use access.
And we have no control over those agencies.
If
We just
he,
enforce
if he
it, yeah.
goes to the state agency and says, they've got an obvious commercial operation going on, go out there and shut them down.
Well,
Well,
I
then
would
he has-
suggest you contact the state engineer for the area, actually call Sean and ask him who he is. I think there's stuff in packets from, CDOT.
Can I,
No reason you can't contact him and, see what the deal is, and same thing with the water engineer.
Well, I have
And try to work
contacted-
it out.
I have
Okay.
contacted them. I don't know what to tell you.
I'm trying to broker peace here, dude.
Yes, ma'am. No, and I appreciate
Yeah.
that. I really do.
Yeah.
I really do. He's ignoring the agriculture exemption in specific development.
But I disagree with the agriculture exemption.
yes.
The bath.
Quotes from the county.
Just gonna.
this is Ty Mossholder, Tim's attorney. Do you mind if I butt in for just a second here?
Well, we're 2.5 hours in, and it
Yeah.
seems like a lot of the information, and it's, you run it however you want to. A lot of this information is duplicative at this point. Mr. Austin has made a lot of good points, but I'm kind of hearing the same points being made.
Mhm.
We don't have a room of people that I think want to
Yeah.
probably,
Yeah.
I'm just gonna, for the sake of it being 8 o'clock.
Yeah, we do need to move this along and get, all the people that signed up.
So Tim, tell me, are you and your partner, are you guys willing to work with Delta County?
I'd like to hear-
Free slate,
I'd like to hear from my attorney, if that's okay.
that's fine,
Okay.
but that would,
Well,
Go a
you're
long
asking me to
ways,
go
yeah.
into a system of people that are willing to do this to me.
that's
So,
what you have an attorney for.
Right.
Please, Tag.
Thank you. And I'm going to keep my comments very brief. I just wanted to address the points that you guys asked for the attorney for very quickly. So I think Mr. Gardner is both correct and incorrect on his contention regarding the 2019 specific development regulations. He is correct that the planning department zoning classification is what matters, right? It's a legal term of art. It is what you say it is. It is a product of statute. But these businesses, right, all these agritourism businesses ultimately started off as Airbnbs, which were permitted residential uses and are sort of disputed, sort of operate in these legal gray areas, right? The county didn't know what to do with them. And so what they were doing was classifying them as agricultural because there was these mixed agricultural uses going on the property. Under the then existing agricultural exemption, they weren't subject to commercial regulation. We aren't contesting that these guys do commerce on their property, right? Farmers do commerce on their property, but we don't consider them commercially zoned. The problem is the 2024 code didn't provide for these agritourism businesses. So all of a sudden they were left stranded in this gray area. And now the planning department is changing its position that they were exempt agriculturally zoned and saying that they're commercially zoned, right? And that is significant because that is what ultimately subjects them to all of this compliance. I completely agree with the commission that some of this is outside of your hands now. The horse is out of the barn with respect to the water issue and with respect to the CDOT issue. I agree that we're going to have to resolve those independently. The problem is that CDOT indisputably wouldn't have acted on this case but for the bona fide and certain representation by the planning department that this was a non-compliant access, right? Without insufficient information to make that determination. And that's the point here. And so that's all I'll say for now. I'll hang up and listen, but that's all I wanted to butt in and clarify.
Thank you. Brittany, do you have the form of the constituents that would like to speak? Mr. Allen, thank you very much. We'll move on to the public comments.
Did you not have any questions? Okay.
Okay, please again, be mindful of time, 3 minutes. When your name is called, please make sure to introduce yourself, give your address, and proceed with your comments. Make sure they're focused on the agenda at hand and constructive. Make sure all of your comments are reflected to us and not to the public, or to other people.
And if you agree with the person that just got up before you and said the same thing, say, yeah, I'm me. Here's my address, and I agree with that person. Just
okay.
In type of brevity. Yeah.
Mr. Mitchell, Scott Mitchell.
Good evening. My name is Scott Mitchell and I live at 40881 Highway 133, also known as Sageview Ranch. I'm co-creator out there. The county says it supports agritourism, that it recognizes agritourism as a function of agriculture. Yet at the same time, it's attempting to reclassify agritourism as commercial land use, turning family farms like mine, Mr. Austin's, into commercial enterprises. County administration admits itself agritourism is not used anywhere in the Delta County land use regulations. Goes on to say agritourism could include farm festivals, outdoor recreation, wedding events, guest ranches, etc. If the activity involves remuneration, then they are commercial. Think about what that means. What about the Delta County Fair? Are our kids who sell and show animals now operating a commercial business? How about the fellow that maybe sells 100 bales of hay a year? Is he a commercial enterprise? Is the goal to commercially tax agriculture out of existence? That's not supporting agriculture. Now let's talk about the complaint form that we're all here about, because this case rests upon whether the director gathered clear and convincing evidence, right? The records show he did not. On that complaint form, there was no articulable complaint. The form was not completed accurately. Fort Austin was not even listed on the complaint. Fort Austin has operated legally under the agricultural exemption since 2014. That evidence was ignored. There was no field inspection was completed within a 30-day requirement. And most disturbing, another business name was added later in green pen by staff. after the form was signed. Why wasn't Fort Austin just added then? That's not just unclear, that's deceptive. The system has already torn 3 neighborhoods apart: Needle Rock, Rogers Mesa, and Tessamon Road. Now it's attempting to tear our neighborhood apart. The director accepted a blank complaint with no stated violation, allowed a verbal complaint based on CDOT violation, not land use code, and never ensured a site inspection occurred. You cannot claim clear and convincing evidence when basic investigation was never done. Even more concerning, during another venue review, the director had to ask that applicant where their opposing neighbors lived. When he realized they couldn't even see the venue, the opposing neighbors that is, he said, "I don't understand why they're complaining." He relied on the applicants instead of verified facts. Now, the staff report published for this meeting, let's talk about that real quick. Page 3 incorrectly states the complainant lives off Highway 133. They live off Highway 92, and misstates the turn lane requirements. Page 6 implies an approved change of use that never occurred. Page 7 ignores 2021 satellite data and dismisses dates. I'll wrap it up quickly. Page 7 also claims no agricultural exemption applies despite written emails from county officials in 2017 and February 25 saying otherwise. Page 8 references an unidentified code chapter. Page 9 dismisses investigative failures relying on the same flawed investigation. Page 10 claims the evidence overwhelmingly supports the decision. Respectfully, it does not. This is not clear, this is not convincing, and it's not fair. Please protect agriculture. Oh, before I do that, one more thing. One of the slides that the director put up on the screen here, he purported that was from the 2021 land use matrix. It was not. The 2021 land use matrix has the zoning districts of A35, A20, A5, R1, rural industrial commercial, and UGA.
Mr. Mitchell, we have to wrap it up.
The director put a matrix up there that included Res 1. Not even clear, not convincing evidence. Do the right thing, protect agriculture, due process, and community. Thank you for your time. Thank you for your assistance.
Joel, Lori?
I'll try to do this quickly. Okay. Good evening. My name is Lori Mitchell. I live at 40881 Highway 133 in Paonia. I am co-creator at Sageview Ranch, one of the properties named in the so-called complaint. I'm here to explain why the planning director's determination was not lawful and why it was used without clear and convincing evidence. Under the county's 2024 Land Use Code, Chapter 13, Section 4B1, enforcement begins with a valid complaint, followed by a mandatory field inspection within 30 days. That inspection never occurred at Fort Austin, Sageview Ranch, nor at Zen Zen, and there were no valid complaint. I personally met with the Davises who submitted the complaint form, and they live 11 miles away in another town. They told me, as on record with the Planning Commission and the Board of County Commissioners meetings, that they did not file a land use complaint against any venue. Their concern was solely about the CDOT infrastructure requirements related to the new venue. They explained that they were advised by the code compliance officer to complete the form so that CDOT questions could be answered for them. The board should also be aware that after the form, well, I'm not going to say that because Scott already did. When a document that initiates enforcement is altered by an enforcing authority, that is not a clerical issue. It raises serious concern about procedural integrity. And under the Land Use Code, the planning director is responsible for enforcement actions taken by his department. He is bound by the Land Use Code and accountable for compliance with it. It goes directly to the validity of the enforcement action itself. Sageview Ranch then spent 5 hours in meetings with the planning department. We submitted extensive documentations. We were told by the director a determination would be issued within 3 days. Instead, 2 months later, we received a notice labeled unlawful nonconforming, only to find out that wasn't even a determination at all. It just was an offering to give us a year to comply with the new code. That is not clarity, that's moving the goalpost. Colorado Revised Statute 3028-120 and Delta County's own Land Use Code, Chapter 11, Section 1A, 1B exist for a reason. They protect legal non-conforming uses. They protect the established businesses. They protect reliance, investment, and fairness. When new standards are imposed without due process, public trust erodes. That is not how land use code is meant to function. This retroactive enforcement to long-standing established uses, it undermines due process for every single landowner. As a board member of the Colorado Agritourism Association, I want to note there are 64 counties in Colorado that have agritourism. There's 64 counties in Colorado. Delta County ranks 8th in agritourism operations and 3rd in agritourism revenue statewide. This is not a marginal activity. It's a growing economic engine for a reason. So the questions before the board is not legal, it is fundamental. It's also fundamental. Why would a county choose to target agritourism, one of the strongest drivers of rural vitality? And what message does that send to every single landowner, every farmer, and every family considering whether to invest here? And before the county enforces a new land use code, it must follow it.
Thank you, Ms. Mitchell.
If this determination is allowed to stand, I'm almost done, just really quickly. If this determination is allowed to stand, long established businesses may be reclassified without investigation, without due process. And for these reasons, I respectfully ask this board to reverse the planning director's determination. Thank you for your time, and also thank you for your service to the community.
Thank you. Right, so this one's a bit ambiguous. Miss
Yes.
Pamela Jackson, would you like to come up?
I do not have a prepared statement. I was just gonna listen to what everyone, they can hear me without the mic. Oh, maybe you can't. Maybe Nico Wolf can't hear me because he's on the heat. Anyway. I just go right for the throat. I think that the man who did this complaint form needs to be held accountable before there's a lawsuit. And I'm not wanting a lawsuit. Delta County doesn't want a lawsuit. Nobody wants a lawsuit. Whoever did this in the unethical way that they did it, they need to take care of it. And so full stop, we should be done. Number 2, they need to stay agritourism, however we can make them. I understand water rights. I understand now that these guys have opened up a kettle of worms for Sageview Ranch and for Austin. And I know now they're gonna have to do something about the water. And I'm really sorry, and I hope that they can come to some agreement that's gonna work. And I know that they would work with you if you could keep it agritourism. 3, I don't want to discourage creative, innovative people from moving here to do these exciting kind of things that they are doing that are showing people that agriculture is really actually a wonderful way to live. You know, my property is zoned to agriculture. I make $100 an hour as a music therapist. And when I make some plum jelly from the plums on my land, how much money do you think I make when I sell that jar of jam? Maybe 50 cents. I don't do it for the money. I use organic sugar. It's clean. The people that and I keep my agricultural status by doing that. Number 4, this is just a little story. I travel every year. I go to Ireland because I'm a musician and I'm Irish. I was at the Dublin airport. The 3 gals in front of me were talking and they turned around and said hello to me. And I said, "Where are you going?" And they said, "We're going to Colorado." And I said, "Well, great. I live in Colorado. Have you been there before?" "Yeah, we went to this great farm stay. It was in this little town. I can't remember the name of it. But the place was called Fort Austin, Dublin. Girls from Dublin, they couldn't stop raving about how nice their stay was at Fort Austin."
Thank you. All right. Mike Jackson, are you still here? I think he made a comment earlier. Okay.
I think he left, yeah.
Moving on, Sam McGee? Did I say it right?
I think so. Close enough. Good evening, everybody. We're all tired. We've been here for a couple hours, so I'll be brief. I'm an outsider. I'm from the Denver area, Sam McGee. I'm a retired law enforcement officer after 45 long, hard years. So I appreciate enforcement. I appreciate holding our communities accountable, but that has to be by the standard of being fair and equitable, right? And unbiased. I think there's a crisis across this country with having faith in some of our systems and our institutions that we no longer have faith in, to include government, education, and maybe even houses of worship. Tonight, what I've heard is a crisis with local government. And what I've heard is not so much a debate over the statutory authority. I don't think there's any debate over the statutory authority of the director and his staff. What's up for debate tonight is the legitimacy of the process and maybe even the people involved. And I know in policing, there's a crisis across the country with trust. And that stems from the legitimacy. In other words, everybody knows we have the statutory authority, but do the people in our community believe in our authority? Do they trust that they're going to be held accountable, but in a fair and equitable way? And that's where trust breaks down. And that's what I've heard tonight is that there's no debate over the statutory authority of the director, but there's a lot of question about the motivation, the targeting, the appearance of impropriety. And so if the standard for a clear and convincing result is the standard, you cannot have that and still have a question over the legitimacy of the complaint, starting with the complaint and with the process as it is required throughout the code, the protocols, the steps. And so your community is upset with you over these issues. And so I challenge you, and thank you, by the way, for your volunteer status. I think that's the highest form of service there is. But you also have an opportunity and an obligation, I would say.
We always have openings for
Yeah.
volunteers.
You're about 3 hours away from where I live, so it'd be a bit of a trip. But I love the notion of public service, and I love the notion of trying to do the right thing. So you have an opportunity tonight to press pause and to make this right and course correct. Thanks so much.
Thank you. I apologize. I cannot read this name. It starts with a D and from Cedar Edge. Okay.
Hello, my name is Dana Colburn, and I live at 485 4th Street in Cedar Ridge. I am very unhappy with our director and our investigator, and I would like to request that Neil Everett be removed from his position because of his
I would like to remind you that we need to keep the comments
oh,
regarding.
this
the-
is about
Not personnel, but regarding,
We have no control over who works at the.
and we're trying to use the time
Okay, we
efficiently
need to
regarding
stick to the
what's
matter
on the
at hand.
agenda.
So my time was not started over. I just noticed that. So start my time over, please. It's at 2:15. I haven't been speaking for 2:15. Oh, it's running down. Okay. All right. So you are asking the Austins to expensively comply to the standards in the 2024 Land Use Code. That's wrong. To me, you have a lawsuit on your hand. This county needs to support agritourism. But most importantly, we need to trust the people that we're working with. You're asking them to work with these people. How can they possibly trust these people? You can't. I wouldn't trust them. As he types and is not listening.
Actually, talking what you think.
Again, please make sure that.
Stick
this is
to the matter at
constructive
hand,
time.
please, yeah.
The Austins should be completely grandfathered in. This office should be calling CDOT and the water board and say they screwed up. And stand behind them. That's what needs to happen here. Nothing else.
Yep.
We have moving targets that we can't trust in this office. You have a lawsuit on your hands. I suggest you figure out how to make it right to the Austins, to Sageview Ranch, and to Zinzin Gardens, based on this document that started it all. The determination needs to be reversed. And that's all I have to say.
Thank you. Daniel Ziskin? Did I butcher that one?
No. My name is Daniel Ziskin. I live at 338 Box Elder Ave in Paonia. I have had a career as a atmospheric scientist. I've opened a small business. And I'm currently the board president of the Paradise Theater in Paonia. And I'm here speaking on my own. This is just my own opinions. I do have a cousin. He's a lawyer, but no, his name is not Vinny. And he teaches law at Washington University. And he said, this is what he tells his law students. He says, it's very difficult to convince a jury about what is fair. You have 12 different people, all the different perspectives, but it's very easy to convince people what's not fair. And we can smell unfairness from a mile away, or in my case, like 30 miles away. And this is just unfair. Whether, regardless of the laws being and the codes being complied with, there's an unfairness where Delta County says, we love agritourism. It's a huge engine of our economy. As Lori said, it was third in the state for revenue generation. And then suddenly our legal and code structure pulls away that foundation of our economy. And so that unfairness is what we're seeing here. And unfortunately, Fort Austin is being pinched in this case. I love Fort Austin. I love Sageview Ranch. I love Zinzin. I've visited them many times and hope that we can really address the fundamental unfairness. And so with that, thank you for your time.
Thank you. So the next three folks on the list have not checked either box, so I just want to confirm whether or not you do want to speak. Susan Lindsay? No, can I mark the box no for the record? I'm marking it no. Chuck Cherrick? Okay. My left. And Stan and Jalen Park?
Baylor.
Okay, thank you. Just wanted to clarify. Okay, that is it for everyone that has signed up.
If you want to ask if anybody's online.
Oh, yeah, thank you for bringing that to my attention. Is there anyone online that would like to publicly comment?
Russ Christensen.
Russ, can you talk loud? That speaker in here doesn't work real well.
Russ Christensen, 33101 J Road, Hotchkiss, Colorado. The points that I want to bring up is number one, this is the Tim and Lori and the folks from Zinzin Garden are faced with this dilemma due to the actions of the planning committee. Let's make no bones about that. The origin of the initial filed complaint has serious ethical and legal violations. Handing somebody a blank warrant to approach and inspect a property to find whatever you want to find by law violates the nature of filing a complaint and using municipal or county codes to pursue whatever you find. It needs to be defined in advance. We're taking a verbal that should have been recorded on a complaint document and taking somebody's word for it. The problem with that is they can adjust that complaint to whatever they find because they left it blank. So the ethical nature is going to go before Colorado's Independent Ethics Committee. So I advise that the that the Board of Appeals here, knowing that you're the last stand, chooses to repudiate rather than negotiate the future of these venues. The second is, while they may have the authority to do so, if you watch the public record recording like this of the last 10 minutes of the Hawk Ranch venue, you will see the Planning Commission admitting they don't know how to interpret the land use code as it applies to venues and everything else. They admitted that they needed workshops to educate themselves, that they didn't know the overall acting directive. So that brings to mind competence, and incompetence definitely undermines authority in the eyes of the public, in the eyes of your constituents, in the eyes of the elected officials that serve this county faithfully. It can undermine you as well. So what I ask of this committee is, instead of negotiating a compliance path forward, that you make this an example and repudiate this Planning Commission's actions. It's unethical actions. It's move the goalpost procedures that have plagued this county now for over a year and a half. And whether it be complainants or applicants, we have created chaos, dismay. And as far as the first gentleman that spoke regarding investment opportunities, when you have unpredictability in a system, you will drive away investment and you will drive away a sense of community, everything that attracts and draws business to this community. Thank you very much for my time. I'm sorry if I'm not shouting because I'm angry. You told me I had to talk louder, but
You're fine, dude. Thanks.
Okay. So
Thank you.
And repeating the same notion, thank you so much to every single person sitting up there. It's not an easy job, but please do review that Hawk Ranch post 10 minutes on record recorded of our planning commission, just planning department, and members of the planning commission were there, admitting they did not know how to interpret the code or apply agritourism, which was a conversation I had with the committee for over a year, that it was poorly defined, that it was going to get them in trouble. And here they were a year later saying, oh yeah, maybe we should look into this thing. It seems like people are upset. Well, guess.
Thank you.
Thanks.
Hello, this is Dr. Jeff Henry.
Oh, hi, Dr. Jeff Henry. Can you let us know where you're from, please?
Yes, I'm from Colorado Springs, and I just wanted to say a word or two. I have known Tim Austin for the better part of 20 plus years, both as a friend and as a business person. And I want you to know that he is a man of integrity. He's a man of respect. He's a man you should support and applaud rather than treat unfairly. And I have seen nothing here to indicate other than he has been treated unfairly. And as a board, just like law enforcement, anybody else trusted with public trust, you cannot create your own exigent circumstances and then leave yourselves to correct, quote unquote, your own self-created problem. And I think that's what has happened here. You have behaved unfairly. Tim has been treated unfairly. And I just want to go on record as supporting him as a good, honest man of integrity and respect. He has treated you with nothing but respect, and he deserves the same. Thank you.
Or anyone else online? Okay, at this time, we're going to go ahead and close public comments. And defer back to our conversations. If you guys have any questions, statements, I would like to say that I greatly appreciate all of you showing up, and this isn't, there's no fun way out of this, no matter what. So I thank you for coming and speaking on behalf of your citizen. And with that, I don't know if anyone has any follow-up questions at the board level.
I don't think so. I think we've gone over everything that I want to hear about. I mean, we've hit on the same point several times, and I guess I have no further questions for applicant or staff or the attorneys at this point, so.
I don't know there.
No,
No. You?
I don't believe so, no. Okay. Can we entertain a
So-
motion?
Do we move on to deliberation?
Yes, sorry, that's what I
Yeah.
thought we were doing.
All right, yes.
Well, you have closed the comment portion.
you speak up?
Yep.
Let me
Whereas
see if I
you-
can get this heat to shut off.
Okay.
Okay, I did.
So I guess if we deliberate about this, heard a lot of really good points here. But I'm not sure if everybody understands what our decision is going to be. We have been tasked with hearing the information, and we have to make a determination whether we think the director of planning was beyond his authority in what he came up with. The other option is that we can make a decision on, well, that's the land use code. Sorry. What we may do, according to our paperwork, is reverse or affirm wholly or partially. Or they also gave us the option to modify. I'm not sure that modifying either one really works. Either we agree that he, or the department, I'm not picking on you, acted appropriately. It's at this point, the cat's out of the bag, so there is an issue. What was built there, when it was built. I certainly don't want to hold somebody accountable for land use codes when they had done stuff beforehand, but there was specific development codes. And as a member of this community and a builder, I've had to work within those confines for a long, long time. I would really like to see the applicant have a way to get this stuff done. But those personal feelings aside, we have to make a decision whether he acted appropriately or went beyond the scope of his authority. And I think I don't know the right way to put this without sounding bad, but I think
Just tell us what you think.
I think given the information that we have, I think I would be inclined to affirm, which is to agree with his findings. I don't know how you'd make that go away, but we have two options here, really. If I were to vote, I would want to vote to affirm and hope that these folks have another option to go beyond this board and take care of it.
That would be district court.
Yeah,
Yeah.
exactly. So that's, we're forcing him to spend more money to fight for his property rights, and I get that, but there's enough there with when things were built with within the specific development era, and as far as the land use code goes, man, I don't want to see them have to bring up anything that they already had and apply it to the land use code. I wish everybody that's sitting out here was at those meetings for the land use code.
Oh, we were.
I certainly was. And, we're
in the
deliberation.
middle of deliberation session. And
Public
it's closed.
So that we had an opportunity to voice our opinions, and even being a member of what we're doing now. And when I was on the planning commission, I certainly didn't like a lot of the stuff that was presented to us, and some of it got adopted. I think we're going to see more of this stuff if we use the land use code. It needs some looking at.
It needs
But
a
every
lot of
time
looking
that
at.
somebody comes to us, and especially with the venue stuff, there's road issues, there's all kinds of things that people haven't even thought of to complain because it hasn't been brought up by a process here yet. But that's just my 2 cents, and I don't feel good about it, but I think if I were to make a decision, that's where I would have to lean at this point. And that I hate to disregard all that good information that we've had here, but that's not what we're voting on. We're voting on 2 things here tonight.
So you want to go Kansas or you?
Yeah, again, very difficult situation, and once the state level gets involved, and findings and evidence is presented, our hands are tied at that point, given the evidence that we've gotten in the testimonies from not only you guys, but from the director as well. Anything outside of, the communication we've received, it's really not up to us. We can't fight this battle for you, unfortunately. There's some things to overcome as far as the well permitting through the state, the CDOT access, all of that's been outlined. We can't undo state procedures and rules.
You can reverse the now that saying evidence without going through the action.
Yeah, we're in the middle of deliberation. Public comment has been closed. Kim, do you have anything you'd say?
Oh, I do. And I vote for the piece down the middle. I just can't get past the fact that the persons who made these complaints, number one, I don't think they were adequately filled out. It was in retaliation, and I have a problem with that.
Is that drafted up in the land use code? I mean, I know it is because I actually read it.
Yeah.
But
I believe
it can be even anonymous from what I read. Now, they don't have to even consider an anonymous complaint, but
But
it
this
can
was-
be.
This was a retaliatory thing.
Well,
and I
then
have
that's a
problem
civil
with that.
matter.
It is. However, we're talking about a lot of money here, and
You're right.
somebody that shows up at the counter and puts 3 business names down and has no reason, nothing other information, that's not a valid complaint. We never should have taken it, and we never should have investigated it. We needed to hand it back to her and say, fill this out and tell us what your complaint is. So from that point forward is my, but I would also like to see Mr. Austin work with the planning commission to salvage your business, to keep it. But you're gonna have to, it's gonna be a give and take thing. But my first thing is, I don't believe that either of those forms, I saw both of them, and they were done by somebody who was just pissed off that they had to pay CDOT. No, it wasn't him. That's a state thing. And you're gonna have to, if you want to try to make this work out, and I hope you do.
Just to add into that, this is a legacy that they've built. This is
I know.
an amazing business that they've built. And I hope that at the state level, they can get some resolve.
Yeah, I do too. And I would point towards that, not necessarily. I disagree with the decision only because I don't think the report should have ever been taken. I would sincerely hope that the planning commission could find a way to work with Mr. Austin to make your business viable, make it profitable.
Can't do it. What these people did to us, is what these people.
Okay.
Mr. Investor, what's your take on this?
Are we good?
Yeah,
Okay.
public
All right.
comments have been closed.
Okay.
You heard it.
I did, but yeah.
We'll pull up, sell, and exit. That's
Mm,
my goal.
Okay,
And we will.
public comments have been closed. Please be respectful.
She asked me a question.
I
Public
did.
comments have
Yeah.
been closed.
I'm sorry, I can't get past that point.
I
That's
understand.
where I am.
So the procedural part is
Yeah.
not great. I understand that. But
Planning department
here we
been
are.
turmoil
We have to
for-
make
Yeah,
a decision. So
I vote if we can modify the order to attempt to bring him into compliance.
we're not,
Otherwise, I'd vote no.
we're not modifying an order. We're just
I know.
deciding whether or not we agree with the director's
Yeah.
decision.
No.
And I say no.
Yeah, sorry.
Needs to be a motion. Also, the land use code does say that you can modify the decision. What that would look like,
Yes,
I'm not sure.
Okay.
But just to be clear.
yes, I would say, let me amend that. I would say, I would hope that Mr. Austin can work with the planning commission to modify. I don't believe this was the director's fault, but I am voting no because I don't think the original complaint was valid.
So I guess what we're saying is there's no motion, there's nothing to vote on.
Correct.
Someone needs, if you want to, it's before you, somebody needs to make a motion before there's any voting.
Yeah,
correct.
So I guess if you're done with your deliberations, it's time for a motion.
Well, we haven't heard from the chair yet.
Yep, it's your turn.
And just as a point too, for us 3 to remember, it's gotta be unanimous.
No.
Well,
So,
well, not exactly.
right,
It has to be unanimous to overturn
over,
the director's.
oh, Candace.
Yeah. Number 3, give us your thoughts.
Yeah.
Because I'm gonna die on this hill.
That's okay. Everything that's been presented and given to us regarding the decision made by the director, regardless of if we agree or not with how the complaint came in, it triggered a series of events that led us down this path where a determination was made. And that uncovered quite a bit. It uncovered, things that are outside of our capacity with the water, the wells, CDOT.
But those are things the planning department should help them with. They should
But
help.
these
them
have
say,
been
yeah.
uncovered. So I would be inclined at this point to move forward in agreeing with the director's position on this. And I would hope that Mr. Austin would take this to his attorney and seek counsel at the state level. Because the procedural part of it, the investigation part of it was right there.
Agreed. But I'm maintaining that the complaint was invalid in the beginning. And I'm basing everything after that is, I don't think Sean's part was necessarily wrong, but I do not believe that those complaints, they were done by the Davises, and it was a retaliatory thing. And that is not a reason to waste a whole bunch of planning commission's time. So I'm not budging on, yeah.
Okay.
I'm ready.
Okay. Can I entertain a motion, please?
Would you like to make a motion?
I would vote I would make a motion that we have the planning department attempt to work with Mr. Austin on bringing his place into compliance, especially at the state and local levels. Failing that, because I believe the original complaint was taken improperly, I don't believe that I can support just a pass.
Okay, the motion has been made. Any seconds?
And just for clarification, the options that we have, would that fall into reverse?
Yeah.
Wholly?
Mhm.
Okay.
Do you want to restate your motion?
All of everything I said, I just want to reverse it.
Okay.
Yeah.
Okay, the motion has been made. Is there a second? Okay, hearing a motion and go ahead.
I'll go ahead and second the motion so that we can vote on it. Unless you have a different motion.
Wait, I'm confused. Say that
You have to
again.
put- If I second the motion, we still have to vote on it.
Okay. Okay, the motion has been made and seconded.
All in favor?
All in favor?
Aye.
Opposed?
Aye.
Aye.
Motion.
Motion fails.
You're killing this county.
Ridiculous. The people have a right to referendum, and this is going to the US Supreme Court. That land use code will be gone. It might take us 10 years, but the people have a right to referendum.
Thank you.
You're a lawyer, you know
Thank you.
that.
Thank you. Okay, moving on to department reports. Oh, Scott. Is there another motion to entertain?
I don't know that the outcome would be any different, but I could make a different motion.
Can't hear you.
I don't know that the outcome would be any different, but I could make a second motion. In the case of APL 25-001 Fort Austin, I would make a motion that we affirm the director's work and not modify anything. Just a straight affirm.
Okay, straight affirm. A motion has been made. Can I get a second? Hearing no second, can we put that to a vote? Nope, we don't have to do anything, sorry.
Nope.
I can. Do I have to say that?
It's fine.
Okay.
If that's what you want to do.
Okay. All right. Yes, I would second that. Motion has been made and seconded to affirm the director's position on this particular case, which is APL 25-001 for Austin. All in favor?
Aye.
Aye. Opposed? Aye. Okay, the motion has been approved to affirm the director's position. Thank you very much. And if we can move on to the department report. No department of report. Okay. Thank you all. I'm going to go ahead and adjourn the meeting.